Welcome back to Heart of Employment, the show where we answer your questions about California employment law and give you the tips your boss doesn't want you to know. Today, my guest is Senior Counsel Adam Sherman. Adam, hello.
Hi. They only don't want you to know if they're breaking the law.
That's right, and that's why we're here to educate the people. Today, we're talking about common misperceptions because I'm sure as you've seen in your work, there's a lot of misperceptions out there.
There are a lot of misconceptions. I see it most often when it comes to harassment, but sometimes discrimination in general, just in the workplace. It's very different than regular average life.
Yeah, so that's a great place to start. There's four main pillars in employment law that most lawsuits are based on, correct? Can you walk me through those?
Yeah, it's kind of an oversimplification, but
Right, that's what I do.
Yeah, exactly. It just makes it easier. The first is kind of one set of categories, which is essentially the discrimination, harassment, retaliation. And they typically end in wrongful termination.
Okay.
Wrongful termination is kind of a catch-all phrase. There are laws in California specifically called wrongful termination, but it ends up being duplicative. It's very legalese. It's a lot of jargon. But discrimination, if you fire someone, for example, for their race, you don't need to have a wrongful termination claim. That is discrimination. It encompasses the wrongful termination, and that's under the Fair Employment and Housing Act in California.
So while we're on that topic then, give me an example of wrongful termination just on its own.
So a wrongful termination really on its own isn't a thing. It has to be connected to something else.
Interesting.
Most law in California is pretty employer friendly, and that's true all over the country. As far as employment law and protecting the employee, California is much more protective than a lot of other states. And so there are benefits, but there are narrow carve-outs. An employer can do almost anything they want, with the exception of a few narrow carve-outs. They can't fire you for being a member of a protected class. They can't fire you for being engaged in a protected activity. But other than that, they can pretty much do whatever they want.
For any legal reason,
For any, exactly, yes, legal reasons.
So let's go over harassment. I think harassment is one of the most misunderstood topics in employment law. Would you agree?
I would definitely agree. Yeah.
So explain why harassment is so confusing for employees.
Well, this is probably true even with discrimination and retaliation, but the English language words are not the same as the legal definitions.
Yeah.
And so a lot of people are like, my boss is harassing me. In the English language, that's true. You know, your boss is being a jerk. But
yeah.
Unfortunately, it's not legal to be a jerk. And so there are misconceptions as to what harassment really is. And a lot of people use those words thinking that they are being harassed, but I would say let the lawyer do the analysis and tell you if it's actually harassment.
So go a little further with that then. So what is illegal harassment?
So illegal harassment there's two main types really. One is a hostile work environment, and the other is, some sort of sexual quid pro quo.
And hostile work environment, again, I think a lot of people think, well, my boss calls me name, hostile work environment.
Right, yeah, and if your boss is just a jerk, that's not harassment, right? So now if that behavior is because you're a member of a protected class or you engage in a protected activity, then it is. So for example, if your boss is making a lot of sexual jokes and it's offending you, right, that is sexual harassment, that is harassment. If your boss is making racial jokes, right, stereotypes, that's harassment for race. But if your boss is just yelling at you because you're late and giving you a hard time because they're micromanaging or nitpicking your job, they're just a jerk.
Yeah, and there's a lot of jerks out there.
There's a lot of jerks out there.
And unfortunately, we can't see them all.
And actually, I know there are a lot of jerks out there because I get all these, questions and intakes, people calling, being like, my boss is such a jerk, this is what happened, are they harassing me?
And we see that a lot in our comments on Facebook, Instagram, TikTok, like, my boss is a jerk, my boss calls me names. And it's like, that sucks, and you shouldn't have to work under that environment, but it doesn't mean we can help you sue.
True, and I would say, there are times when that harassment is kind of underhanded, and it is there. For example, my boss is kind of a jerk to everybody, but I got injured on the job site, had to take time off, and then my boss it was a whole different ball. They started icing me out. They completely ignored me, told people on my team not to talk to me. That's, now I've tied that harassment, that boss being a jerk and that hostility specifically to your injury. Now that's harassment.
And that gets us into retaliation, because that's basically
yes.
retaliation as well.
Yes.
So people always like, I put in my 2 weeks notice and got let go right away.
Yeah.
That's retaliation. And the fact is, not all retaliation is illegal retaliation. Yeah. So walk us through illegal retaliation.
Yeah, so the English language word retaliation is not always illegal. The legal retaliation is because of a protected activity. So the adverse employment action, the firing, the demotion, I took your company car from you,
Right.
those are specifically related to you engaged in a protected activity. And usually when it's, there's one kind of category of protected activity, and that could be related to the FEHA. So,
What FEHA is?
Fair Employment and Housing Act. Yeah, so I complained about being sexually harassed, and then I was fired.
Right.
That's retaliation. I complained that my boss was using the N-word, and then I was fired. That's retaliation.
Okay.
I complained that, hey, I got injured, and my doctor gave me a doctor's note and says, you can't lift more than 10 pounds. My boss keeps telling me I have to lift these boxes. They're really heavy. And then I get demoted. That's retaliation. So I've had that adverse employment action, the demotion, the loss of benefit, the firing, and I've connected it to the protected activity. It's because I complained about something illegal, because I complained about discrimination, harassment.
And what we see a lot, which isn't typically illegal retaliation, is I complained about long hours.
Right.
I complained about heavy work. We get a lot of people that say, one employee was let go. Now I have that workload and my own. I complained and I got demoted. That can't be legal, right? Well,
Probably is.
Yeah.
Most of the law school answer is always it depends.
right.
There's never a hard set answer. It just depends on the facts. But most of the time, employers can kind of do whatever they want. I think the purpose of the law in California and the purpose of the law in general in the country has been made very clear that we're not regulating good business, meaning we're not making it illegal for employers to be stupid. We're not making it illegal for employers to be bad businessmen or women.
Right.
There's just a narrow carve out of things. We're saying, I don't care what the reason is. If you do it because of this, that's illegal.
Yeah. And when it comes to discrimination, I think we probably all know what that means. Is there anything about illegal discrimination that you think needs clearing up?
Yeah, I think there's a misconception. Keep in mind that when we talk about employment law, we're usually talking about the relationship between the employee and the employer, which is a company. And that relationship means that you're suing the employer, the company.
Yeah.
You can't sue an employer sometimes for what certain individuals do. Sometimes you can, sometimes you can't. But the example I give is, let's say someone's walking down the hallway, they yell out the N-word.
Okay.
Right?
Yeah.
Seems like discrimination. It's actually not. That person can't yell that. They can't do that. And you can complain. That could be a violation of the internal discrimination policy.
Yeah.
But it's not legal discrimination. You can't sue that person for that. Now, if the company fires you because you're black, that you can sue them for. That's discrimination.
Okay. I think a lot of people are like, whoa, hang on a second.
Yeah.
So because wouldn't that if there's a person of color working there and they hear that and they're like, well, now I don't feel comfortable working here
Right.
if my coworker's yelling out the N-word.
Yes.
I complain to my boss does nothing. You're saying that person can't sue for either harassment or discrimination?
Probably not. Maybe harassment, maybe depending on the severity.
Yeah.
Harassment has other specific requirements. The main ones in California are severe and pervasive.
Right.
And to the point where it's altering the terms and conditions of your employment. So if if this person is yelling it out on a regular basis, saying all these derogatory racist comments and it's on a regular thing, potentially, but you still need an adverse employment action. You still need to show the company did something or failed to do something. So if you have the harassment there, you could sue the company for it. If it's a supervisor, if it's not a supervisor, the company had to have notice. So you had to complain about it. But just in general, those type of comments aren't something you sue the employer for. It's the adverse employment action.
But if it's a supervisor saying these things, maybe you could.
So when a supervisor is the harasser, in California it's called strict liability. It means you automatically can hook the employer.
Got it. So it does really matter if it's your coworker versus the boss.
The
basically.
requirements change. So if it's a coworker, you now have to complain about it, and then the employer has to do nothing. But if you don't complain about it and they didn't know about it, no one else had complained about it, you can't hook the employer.
So let's say my coworker is saying discriminating things, sexual things. I'm real uncomfortable with what my coworker's saying. I go to the boss. I say, my coworker's saying the N-word.
Yep.
You're saying now that I've told the boss, and if they don't do anything, then maybe I can sue the company.
Correct.
Okay.
Now, if it's a supervisor that's doing the harassing,
Yeah.
you can probably just sue the company. I think as a practical matter, when you get into front of a jury or something like that, they're going to want to know a little bit more.
What if, I'm just thinking of comments I've seen online. What if they go, okay, we hear that he makes you uncomfortable. We'll move that guy down the hall. So they didn't fire that guy or necessarily punish him or her for saying discriminatory or harassing things. They just kind of separated the two workers. Is that okay? Does that count?
If it stops the harassment, then yeah. I mean,
Okay.
the issue is not that they have to punish or do something to this person. The issue is that they have to protect you as the employee from this environment, from this hostile work environment.
Right.
So if the hostile work environment stops, then yes, they've done their duty.
Okay.
Now, again, though, if it was a supervisor who did the harassing, it doesn't even matter.
Yeah.
They've already been hooked.
Yeah. So it's just that big difference between
Yes.
supervisor and coworker.
Yeah, and I think it makes sense, right? Like the Fair Employment and Housing Act, the FEHA, it defines supervisor. So we're basically allowing supervisors to make certain decisions on behalf of the company. You know, if they have hire and fire authority, it's the same idea, right? Like this person is acting on behalf of the company. And so I think that's kind of the purpose behind it.
Let's do some rapid fire questions.
Okay.
Is this harassment? And we'll say it's from the boss. Okay,
Okay,
so these
all
are
right.
actions the boss might do. Would this count as illegal harassment? My boss yells at me.
No, but maybe.
Okay, we'll get to the maybe afterwards. My boss swears at me.
Still no, but maybe.
My boss embarrasses me in front of a group. They humiliated me.
Probably not, but maybe.
My boss calls me names.
No, but maybe.
Okay, what's the maybe?
It's always, you know, in this case, it's always if it's tied to a protected class or activity. So if your boss is calling you names because they're a jerk, it's not harassment. If your boss is calling you names because you're black, that's harassment. If your boss is calling you names because you got injured at work, harassment. If your boss embarrasses you because you asked for, you know, time to go to the doctor, discrimination, right? Harassment. But if it's just because your boss is a jerk, it's not.
Kind of makes you sit back in your chair and think,
I know.
What kind of world are we living in here?
I know. And, you know, interestingly, one of the worst things that can happen, I have a lot of clients, they'll come to me and they'll tell me, you know, they'll be describing their case. And especially in deposition, I have to warn my clients because a lot of people think bad behavior, things that are morally bad,
Right.
help their case. So they'll say things like, man, my boss, you know, he was such a jerk. He was so terrible, but he was like this to everybody, right? Like he treated everybody terribly. And I'm like, you just shot your case in the foot. Because the truth is, you aren't being singled out because of your race or disability or protected class or protected activity. You're now just one of the many people that your boss is a jerk to. And it has nothing to do with these protected classes. So now it's not harassment, it's the jerk boss. So just because your boss is a jerk and just because these bad things happen, you have to make sure that it's tied to that protected class or protected activity.
If it's happening to everybody and not just you, then it's not singling you out.
Right. Now, the exception to that, always the but, right? If it's happening to everybody of your class,
Right.
meaning it's only the women who are being treated this way,
Right.
that's different.
Now, let's flip that around. We get a lot of, my boss treats, you know, I was late and my boss punished me. 7 other employees are late.
Yeah.
They don't get punished. That must mean I'm treated unfairly and I want to sue.
Again, that could be true if it's related to a protected class. So, for example, if you get into a car accident, even not at work, you get into a car accident at home, you got a knee injury, and you give a doctor's note that's like, hey, I need extra time sitting down, or I need extra breaks, or something like that. And now your boss is being this extra jerk to you.
Right.
That's different, right?
Okay.
That's different.
But yeah, just because not everyone's getting punished equal, if you're getting punished worse than another employee for certain activities, that's not necessarily illegal unless it's due to the protected class.
Yeah, the favoritism is not, and neither is the nepotism. I get that one a lot
Oh,
too.
yeah.
Yeah. You know,
Yeah.
so just because it's like, well, they fired me to hire their niece. It's like, well, that's not, that's
Yeah.
not illegal.
Right.
Usually.
What about cases you've dealt with personally? I think you were telling me about a constructive termination
Yeah.
case. And constructive termination, it's been a hot case for us on TikTok.
Okay.
Because people hear, oh, like I was treated so badly that I had to quit, but then they equivocate that to everything we've talked about.
Right,
They
right.
call me names. I have emotional distress. The anxiety because of what my expectations were so huge. I saw this the other day. A woman was like, I had to go to therapy because my boss is so mean or the work is so much, I can't handle
Yeah.
that. And so people think that equals constructive termination, but it often doesn't. So I'd love to hear about this case that you
Yeah.
were successful with, correct?
Sure,
Go
yeah.
ahead, tell us about it.
So before I jump in, I will say that's like a no but also.
Uh-huh.
A lot of times, the constructive term is very hard and it is a very high burden. So first, let's just talk a little bit about it before I tell my story.
Yeah.
The constructive term is, it means that you essentially have been put in a position where even though you say the words "I resign," it's as if you've been fired because the employment situation is so unbearable, no reasonable person would stay. And also that the treatment is so bad that it has materially altered the terms and conditions of your employment. That's the legal definition. It's a very high burden, and so it's tough to prove. There is a very bad case out there that talks about stress from work alone is not sufficient to be a disability or to be a reason for quitting. However, if you have a diagnosis of anxiety or something like that, a lot of times I can tie that and make a case out of it.
Let me ask something real quick about that.
Please.
Stress.
Right.
Now, my understanding is stress alone is not a reason to sue unless the stress is coming from because your boss is discriminating against you or it's illegal harassment. So give our listeners an example. When can I sue potentially because I feel stressed at work?
Well, I would say it like this. First, if you have an actual diagnosis, if you have a psychologist, psychiatrist, therapist, social worker, someone diagnosing you with an anxiety disorder that actually has some sort of stress related to it, that is different, and I would count that as a mental or emotional disability.
Got it.
But if you're just like, hey, work is stressing me out to the point where, my boss is riding me and I quit, probably not.
Okay.
It changes, and again, this case isn't great, but it's not the ultimate.
Yeah.
And so if you have a diagnosis from a doctor, I'm probably going to run with it because I think you should be protected.
Okay. On with your explanation.
So I had a case where a woman had it's along the same line. She had a mental emotional disability, and she had a child. The baby's father and her were not in a good relationship. They tried to work it out, didn't go well, turned somewhat abusive, and she became the sole caretaker for her child. She worked for a big, I won't say the name of the company, but she worked for a big company.
What industry?
It's retail.
Retail.
So
okay.
women's clothing.
Okay.
I mean, all clothing, but women's primarily.
Yep.
Big retail organization that everybody would know.
Okay.
And she said, I have to care for my child because of my mental disability, because of my emotional disability. I have this stress and anxiety disorder. Huh. And I'm so stressed out about my child's well-being because I don't have anyone else, because of this bad relationship with the father. And so she said, I need to work essentially Monday through Friday, and it's retail. And they were like, well, that really doesn't work. We basically require everybody to work at least one weekend day and one weekend night, and that's kind of how it works. And she was asking for basically 9 to 5 Monday through Friday.
Would this count as a reasonable accommodation?
So that was our argument, right?
Yeah.
So we argued that was the reasonable accommodation. They were like, well, this has nothing to do with her disability. This is childcare. She specifically says it's childcare.
Right.
Our psychologist and her treater was phenomenal, and we essentially could establish the link through testimony that yes, the childcare was an issue, but that was triggering her emotional distress. And so in the restrictions that her doctor wrote, she specifically wrote a Monday through Friday to accommodate better sleep schedule, to have her medication be more effective, and the ability to take care of her child so she wouldn't have to worry about the biggest stressor in her life. And so it was a very tough case because constructive term is such a high bar.
Yeah.
And we actually won that case.
Wow. Must have felt good.
It felt really good. And she, our client was just extremely grateful.
Yeah.
So
what do you think the takeaway, as we're wrapping up here, from that story first, what's the takeaway there for our audience when it comes to constructive termination? What can someone learn from a case like that?
It's probably the same advice that I would also give in general, which is document, put things in writing. Make sure that you're clear. A lot of times, people go through these terrible situations where they feel like they have no choice but to resign. But in their resignation, they just say, thanks for letting me work here. I really enjoyed my experience. And then they resign. And I have to try to go to a jury and be like, how do I justify this email that says, thank you, I enjoyed my time here?
Yeah.
But in their mind, they were like, look, I did. Like, I liked this job.
Yeah.
But this one boss made it so unbearable, or this one circumstance. But I loved working here. I love the industry. I enjoyed my clients, whatever it may be. And sometimes, though, they have these contradicting, statements, and it's hard. So I would say, document. Don't be afraid to tell your employer This is what I'm experiencing. My boss is doing X. I feel like I'm not being accommodated.
This
Whatever.
is over email.
Yeah,
Maybe a
document,
personal email that you can keep if you get fired.
For sure, yes. I would say emails sometimes disappear.
Right.
All right. They're not supposed to, but they do. So yeah, send it from, CC your personal email, send it from your personal email, and include more than one person. Don't just send it to your supervisor, send it to HR.
Okay.
And just say this is what's happening to me. They should investigate. They should try to correct it. They should do these things. And I think ultimately you should try to do that before you quit anyway.
Yeah.
See if they can fix it. And if you really do love the job and if it really is great, that's a better solution.
Make an effort.
Yeah.
Before I know we're out of town, I got to ask you one last question.
Yeah.
It's about ChatGPT and AI.
Yes.
I think we got to get this in.
Oh my God,
because,
we got to, yeah.
Everybody's using it. I use it. and as you were telling me earlier, so many people are choosing ChatGPT over legal counsel.
We talked about this briefly, but I'll tell you, it's kind of like I get frustrated because I'm like, if you had a medical issue, would you ChatGPT and be like, I performed surgery on my own knee to remove the tumor because ChatGPT told me that's what the doctor was going to, it's like,
ridiculous.
It's absurd. It's absurd, right?
Right.
But I have that all the time. People think that there's a level of urgency, but the law is a slow process. And most of the time in employment cases, the biggest damages are these lost wages. So the longer you wait after termination, the more valuable your case becomes anyway. But people feel the need to start acting.
Right.
And ChatGPT will give some basic information like you need to go to the EEOC or you need to go to the California Civil Rights Department. And those things are true, but your lawyer should be doing that for you because when you start filling out those forms, it could be so deadly to your case. I've had a case, someone came to me recently. She had a really good case too, really, really good. Never told us that ChatGPT told her to go to the California Civil Rights Department, get a right to sue. We find out after we sign her up. She's like, oh yeah, by the way, I have other documents I need to send you guys, she only sent us things we specifically asked for.
Yeah.
So she sends us this other document and I'm like, you already destroyed your case. You blew it. Yeah, she blew it. And sometimes people do it in a different way where it's like they exhaust only part of the claim and not all of it. And it's very complicated. So don't ChatGPT your own case. To all of you out there, please come to us first. We will always do a better job. We're going to do these things for you. 99% of the things we do on our clients' cases, we do on their behalf.
Yeah.
So you won't do anything yourself. I will do almost everything for you.
Right.
Let me do it.
You got a degree for a reason.
Yeah, and it's a shame because some people have really good cases and they just, they get bad ChatGPT advice.
Right.
Yeah.
We've all gotten bad ChatGPT advice.
Yeah. So don't ChatGPT.
Yeah. That's a good lesson to end on. Adam, thank you so much. And thank you for the work you do here at D.Law.
It was great.
This was awesome. Thanks, everybody, for listening and watching. You can follow us on TikTok, Facebook, Instagram, YouTube. We get a lot of our questions from there, and we take them directly to the lawyers here at D.Law. So we want to hear from you, and we want to hear what you're going through. So until next time, this is Heart of Employment. I'm Dave, and we'll see you then.